Welcome. Welcome to this panel. I am in the role of moderator on this panel, but I warn everybody in the room that I probably will overextend my moderator privileges and maybe contribute substantively, point, counterpoint, or whatever. And I do want to encourage the group in this panel to really be a discussion. These are important times. A lot of people have a lot of thoughts about where do we sit with respect to the law, the impacts of various maneuvers at various levels on the markets that we're all here to try to make flourish and to participate in. And so today we're going to discuss that, and we're going to discuss a range of things. We'll probably wind up becoming a basic lesson in constitutional, civics and the way that the law works in the U.S. at some level. But we also will get into details a bit on some current activities, some anticipated activities that could have notional impacts and so forth. And I'm going to use my prerogative to, if I feel like somebody's saying something and I want to challenge it, I'm just going to warn everybody I'm going to do that. And I'm mostly looking at you, Nico. Okay.
I've been warned.
All right, cool. So this is a great panel. We've got up here on the screen here, we have Nico Van Alsten. I've known Nico for, 20 plus years at least. Partner at Shepherd, which we all know will be Shep, probably before the end of this conference. Christina Wyatt, Executive Vice President and General Counsel, newly minted General Counsel at the Conservation Fund. And Christina, you have a good background also in securities, and so we can get into climate-related disclosure things beyond just cap and trade issues, which I think is also relevant and important in California. And then Andrew, partner at Perkins Coie, and you do a lot in the renewable space.
Yeah.
And have
project lawyer,
and financing stuff. So there are implementers, lawyers who are at the face of these transactions and the financing, and those transactions can become impacted positively or negatively by the legal enabling environment in this country. And we'll focus on this country. We'll focus on the U.S. for this conversation, and mostly federal and the interplay between federal and states, and with specific reference to California. Okay, just to set the table. Fair enough? All right, now with that, why don't I start, Nico, with you? And I'm going to, smiles, everyone, smiles, right? Give us a rundown of some of the more specific, immediate things that are happening, executive orders and endangerment finding type things that are more in the litigation phase. And then from there, we can dissect it, and we'll move across. Okay, fair enough?
I think so. Well, first of all, it's impossible to cover in even an hour. I mean, there's just so many different fronts of litigation with respect to state climate programs and other climate programs, federal climate programs. I'm based in California. We're in California, so I'll be a little bit focused on California. At present, there are, I believe, over 70 lawsuits between the federal government and the state of California, many of which focus on climate issues. I just want to focus for a moment on the one that we're most concerned about, which is a potential lawsuit challenging California's Cap and Invest program. That said, all of these things are interwoven, right? As you, I'm sure, recently saw, the federal government challenged California's reinstatement of Advanced Clean Cars 1 program. ACC 2, the waiver had been withdrawn, so California said, okay, well, fine, you took that one away, we'll go back to the original, ACC 1. And the federal government is sued, contending that the waiver has essentially retroactive effect to the previous waiver that authorized the ACC 1.
All right, let me stop you for a second. How many lawyers are in the room? Raise your hand. Not that many. Okay.
Oh, okay.
I'm going to do a quick step back for just a second. The Federal Clean Air Act has mobile source provisions, so cars, trucks, and so forth, and they have stationary source provisions. They're in different titles. They're in different sections of the Clean Air Act. With respect to mobile sources, there is a very specific provision that California got ensconced back in 1967 because it had a pre-existing law, and if you guys remember the whole LA basin and the extreme air quality problems back in the day. You couldn't see, very far because of all of the cars. And so the Clean Air Act itself has a very specific provision focused on mobile sources that gives California special standing. But in order to do that, they have to periodically seek a waiver of the national fuel standards and vehicle standards from the federal government. They've done about 100 of them. They've never been challenged. Now they're starting to become challenged. Okay.
Right. And in addition to that, other states can, once the waiver is granted to California, other states are free to join California standards as well, and many do. So why do I mention that? Well, it's just one of the many fronts in the ongoing war by this administration on climate programs, particularly in states, but also because even though it's completely unrelated legally to the cap and invest program, it had an immediate impact on the market. Prices dropped. And we see that with the filing of every one of these lawsuits. There's an immediate impact in the markets, in the headlines. People get concerned. And I'll return to that point later on, but I mean, that's just kind of the relevance of this. It's all very relevant. So ever since the April 8, 2025 executive order protecting American energy from state overreach issued by the president, this has been a primary concern that he's going to go after California's cap and invest program. There were only 3 examples given of alleged overreach by states in that executive order: the Vermont and New York climate superfund laws and California's cap and trade law. That was issued on April 8. On May 1st, last year, the administration filed suit against both Vermont and New York. Those lawsuits are ongoing. It kind of cleared, when is the other shoe going to drop on the third one that was mentioned, right? The order itself had no legal impact except to order the Attorney General to prepare a memo analyzing examples of state overreach and what can be done about it. We do know, by the way, that she did in fact do so. It's confidential, but it's there. So they have a game plan, and we'll see to what extent they execute on it. I have been very concerned about a potential lawsuit, therefore, against California's cap and invest program. We all know that the governor and the president troll each other daily. I mean, there's a big war going on between the state and the federal government, right? Particularly on issues of climate. And it's, we have to give the president some due here. It was that April 8 executive order, which was a galvanizing event for the adoption of AB 1207 and the extension of the cap and invest program to 2045. Hopefully would have happened anyway, but it certainly motivated the legislature and the governor to do that. So that's, it's kind of thing, when is this going to happen? Is it going to happen? There's just so much fire around this. We can go on about the legal theories. There's not a lot of lawyers in the room, and it would be very boring, but I want to just focus on what I see as the most likely course of action should the government decide to bring such an action, which I think is fairly likely. And I'll come back to that later.
No, and then we're going to...
Yeah, I'll shut up soon. Don't worry.
Thank you, Nico.
We see a bit of a roadmap to a potential lawsuit in the ongoing lawsuits against Vermont and New York. Even though they're substantively quite different, the arguments being put forward by the US DOJ in those lawsuits is so bold and so sweeping that it would apply equally to California. And it's a very, as I said, sweeping and bold interpretation of the Clean Air Act. Basically saying it concerns emissions, therefore it concerns fossil fuels, therefore they move around, therefore it concerns international trade, therefore it's only solely in the hands of the federal government. Mm-hmm. I mean, it's kind of breathtaking. And moreover, in a recent exchange of briefs, by the way, the hearing was on Monday of this week, the judge was asked firm questions of both sides, so no telling yet where the judge will come down. But in the last round of briefing before that hearing, one of the defendants pointed out, hey, you just issued a final rule rescinding the endangerment finding. Doesn't that take away your authority to regulate greenhouse gases? So therefore, how can you say that you have supremacy clause, you can preempt our program here? And the response was, well, there are a number of arguments, some of which are just plain wrong, but the basic response was, no, you have to look at the Clean Air Act. Because the Clean Air Act gives EPA the authority to make an endangerment finding, we could do so. Therefore, we are alone regulated in this space.
So let me stop there, and let me just frame that up a little bit more, because I think it's important. So going back to sort of civics lesson here, executive order. So the question is, what is the legal effect of an executive order? Just before we get into the intricacies of the Clean Air Act supremacy and under what clause, and does the savings clause under 116 trump the, small t trump the, the other arguments. Okay. But an executive order on its face is not a law, right? Laws are enacted by legislators and legislatures. So a federal law is Congress passes a law, the president signs the law, that becomes a law, okay? An executive order is a executive branch federal agency instruction that governs what federal agencies do in administering the laws that they're charged with administering, okay? So that's the first point. So people, especially non-lawyers, but even lawyers, kind of oftentimes just kind of jump right to the conflation of, oh, well, it's federal law. You see it in your, I'm sure you've seen it in your feeds, your social media feeds, people like having these debates, and they're like, well, no, look, he just put the order out, that's law. That is not law. Like, that is not a correct legal articulation of what law is and what law isn't. Now, that doesn't mean that executive orders don't have any importance. Of course they do. And then when an executive order is trying to draw a link between what a federal law like the Clean Air Act provides and then instructs the EPA in that order to do something or do something else, or to make an interpretation that all climate action in the United States is hereby preempted because of the Clean Air Act. Now you're looking at, well, does the Clean Air Act actually say that, right? Is that actually how the Clean Air Act works? It's not just, the executive order itself doesn't get to just become the law and the interpretation of how the Clean Air Act works. That's the purview of the courts. So that's just the whole system, right? So
But
just to say,
where it hits the ground is that the agencies are obligated to follow the order of their boss, the executive order. So that's when states and others will then sue those agencies, saying you are taking actions that are not in fact authorized by the law.
yeah. And then the thing about California, just to point this out, so we talked about the mobile sources before, and the waiver and the rescission of the waiver. That is a specific provision in the Clean Air Act that ties back to California related to mobile sources. AB 32, the cap and invest program, and all of that is not derived from the Clean Air Act. It's a totally independent state law. And executive orders definitionally do not have jurisdiction over state law. So let's assume the Clean Air Act didn't exist at all. The President of the United States does not have the constitutional authority to tell a state, you can't enforce that law, right? This doesn't work that way, okay? Now, there are principles about, like you said, like international relations and, national, all the stuff that's happening around the world that we're also concerned about. Some of that stuff is constitutionally in the purview of the president. But a state to do a law, executive orders don't just become the federal law, okay? That's a really important point, because at the end of the day, as Nico said, markets react to stuff, but a lot of times kind of markets react not with the full breadth of the information and the analysis and the reasoning. So if I was a market participant and there was a depression in prices because some executive order came out that actually has no legal likelihood of surviving, and we can talk about that, that would be an opportunity for me to go, okay, these are undervalued units in this market, because it's going to be resolved pretty quickly, and when that happens, the prices are going to go right back up. So I just want to say that we got to be careful not to give more legal weight to something than it actually has. And that can sound like a political statement, and I definitely come to this conversation with my own political views that are inconsistent with this current administration. So that's my bias, and I want to share that transparently to everybody. But that doesn't mean that what I'm saying is incorrect, right? The legal foundations for how we're dealing with these issues are as described. And if anybody disagrees, please. So with that, Nico, anything further you want to?
Yeah, let me just, I think it'll tee off of that pretty well. So there are, as you mentioned, in the Constitution, certain things that are given solely to the executive branch. International relations, treaties have to be approved by the Senate, of course, but these foreign affairs are the purview of the national government. So when states start to engage in international relations of any kind, it gets more complicated. There are literally hundreds of agreements, for example, between states around the Great Lakes and provinces in Canada, and they don't have to, the federal government does not get involved. So it's a little bit more complicated, but there's basically that notion. So in the first Trump administration, they sued California's linkage of its program with Quebec. The court ultimately threw it out, but I want to focus on one claim. The third cause of action alleged that California's linkage violated the Foreign Affairs Doctrine, which gives the federal government sole purview over foreign affairs. The analysis went as follows. The court looks first at the state's program and says, is it within the traditional police powers, the traditional purview of the state? And he held in a written decision that was issued that California's cap and trade program overextended its traditional police powers, because it does on its face say, we want to fight climate change around the world. So he said so there, point one, in the federal government's favor. Point two, is it inconsistent with federal policy of foreign affairs? The court looked at two things, the UNFCCC, and said, no, it's consistent with the UNFCCC, and that's the national policy of the federal government. Well, what about, the federal government said, well, we just withdrew from the Paris Agreement. Well, the response there was, yeah, but the argument was, in the pleadings and in the press, was that he's going to negotiate a better deal. With a bad deal for the U.S., he's going to negotiate a better deal. So therefore, the court said, that's too speculative. I'm going to hold that it's not, California's program is not inconsistent with the federal government. Federal government, this time, you lose. But I'm just going to note in passing, things can change, right? Well, things have changed. We've withdrawn from the UNFCCC. I would contend that that was an illegal act, but nobody's going to call them on it because the Senate adopted it. I don't think the executive president has the power to unilaterally withdraw. That's a separate issue. And withdrew from the Paris Agreement with no intention of rejoining. So the policy, in fact, has changed. So if this issue were teed up again, then it's not a Clean Air Act question. Mm-hmm. It's a question of interference with the constitutional power of the president. I think it's a decent argument. It's not. I think it's a loser in the end, but it's a decent argument. Mm-hmm. So that's the kind of concern that I have, that the federal government at some point, I think, is likely to go. And I'll just close with one last thing as to, okay, why haven't they gone? May 1st, 2025, that lawsuit was filed against Vermont. They just, on Monday of this week, had the oral arguments in the briefing. So it's been almost a year. It'll be several more months likely before we get a decision. Then it'll be appealed. You got to figure on the normal course, these things take about 2 years to play out. And you have to understand that this administration, the DOJ has got a win rate in the district courts, the trial courts, the first round, of about 37%. DOJ, that's incredibly low. You can speak to this, Andrew.
Yeah, that's embarrassingly low, sorry.
Yeah, I mean, it's traditionally DOJ is like 90% because they're very good and they only take cases that are strong on the law. They don't care because A, the headlines, the impacts, they care about that and scaring people. And secondly, because they're playing the long game to get in front of the U.S. Supreme Court ultimately. And there, by the way, their win rate is much better. And they're being good about it. They're not appealing every case. They're not stupid. So all of which is to say, if you're playing that long game, even if you can accelerate it with emergency appeals, which has occurred, then it still takes some time. So all of which is to say, I think they may be waiting to see what happens in Vermont, but if they're going to file this lawsuit against California, I would expect it to happen in the relatively near future.
Yeah, okay. Thank you, Nico. That's good. And again, everything you're describing, though, let's assume worst case scenario for the people who care about California law and the markets. That's not what you just described doesn't even actually obviate or eliminate the cap and invest program.
No.
There might be some tweaks around the margins that have to be accommodated here and there, okay, that's like worst case. But the fundamentals, I want to come back to it, like the fundamentals of what they're seeking to do, and I think you raised a really good point, which is like, it may not even actually be a proper legal strategy. It's more of a political theater and sort of market chaos and disruption strategy, just because that's a win, even if it isn't ultimately legally, validated. So there's a lot of that going on, and I guess I would just caution folks who are trying to sort of put this in perspective to just bear in mind one last point, and that is, as was just said by you, Nico, California, there's currently 70 lawsuits, right? California, and there's a couple people sitting in some rows here who have experience with this, California is a well-experienced and sophisticated jurisdiction that is very accustomed to being involved in lawsuits. If it's not from an adverse federal administration, it'll be from a constituency within California. And so everything that they do is run through that crucible of, what are the litigation outcomes likely to be, and so forth and so on. And California's record in defending its program over these many, many years is very good, okay? But I'm not dismissing the points you made. I think you make very good, arguments and, analysis. It's not an argument, Nico, I know that. And you're just pointing out kind of what's out there, and that's important to do that. But I'm here to say, let's not overreact, because frankly, the vast majority of what you hear in the news and what we all fear is kind of like a ghost. So,
But my job was to set your hair on fire. Their job is to put out the fire.
all right, really? So let's keep moving. So that's hopefully that's helpful. If we want to talk more offline about how does the Clean Air Act work on this provision or that provision? What about the savings clause, which basically expressly says nothing shall prevent states from regulating air pollutants? And by the way, this federal government has not conceded or has acknowledged, I should say, that the Supreme Court case defining greenhouse gases as an air pollutant is valid. So all of that, there's a whole bunch of weight and reality that is very good for the preservation of California's program. Did you want to chime in on that?
Yeah. I just wanted to echo maybe your message of hopefulness a little bit. As Nico had said, the endangerment finding, or the repeal of the endangerment finding, is pretty sweeping. It says you can't regulate. We can't regulate CO2 in states. If we can't do it, neither can you somehow, which is really inconsistent in a lot of ways with the cooperative federalism that forms the foundation of modern environmental law. If the feds aren't doing it, then the states can.
The 10th Amendment basically says if the federal government's not doing something, the power is reserved to the states.
Exactly. And I think when, in the context of the challenge to the repeal, the government's going to have to grapple with Massachusetts versus EPA and the statements that Justice Stevens said in that opinion, which was very clear. And they're going to have to grapple also with Justice Scalia's opinion in UARG versus EPA, where he said regulating CO2 as an air pollutant under Title II of the Clean Air Act is perfectly fine. And more than that, it's perfectly fine for you to require best available control technology for these so-called anyway sources. And I don't want to I'm a recovering Clean Air Act nerd, by the way, so I'm a project lawyer now, but I used to litigate Clean Air Act cases.
Hi, Andrew.
Thanks, everyone. It's been 5 years since my last Clean Air Act case. But in UARG versus EPA, Justice Scalia had said those two things. He endorsed Massachusetts versus EPA and even allowed EPA to take one small step further to deal with sources that otherwise would have triggered prevention of significant deterioration for other pollutants. He said, well, if you triggered for sulfur dioxide because you made a major modification at your facility and you have to apply back for SO2, well, surely you triggered for CO2 as well, and so now you have to apply back for CO2, and back can be energy efficiency or it can be carbon capture and sequestration, and who knows what else as technology evolves and goes forward. And the other thing I'll say, and I'll look to Nico to maybe echo this a little bit, the Supreme Court doesn't really reverse itself on questions of statutory interpretation very often.
That's true.
And you have two majority opinions that have said that it's fine to regulate CO2 under the Clean Air Act. So, the Supreme Court's going to have to deal with that. And I will say that the Federal Register notice on the endangerment finding doesn't really try to deal with that.
No,
It doesn't at all. It sidesteps it.
Almost a throwaway.
Yeah. So even reading the Federal Register notice, one might read that with a little bit of a grain of salt, because good lawyers and smart judges, and maybe even the Supreme Court, might be reluctant to throw it out. Now, I say that with the caveat that Massachusetts versus EPA, Justice Roberts dissented, and in UARG versus EPA, Justice Gorsuch dissented, and they both focused very heavily on this doctrine called the major questions doctrine, which basically says if there's a regulatory change that the agency is asserting or seeking to make by rulemaking or otherwise that is so transformative, so expansive in its breadth, and so new to the particular statute, then that it's really a question for Congress to decide. Now, I don't want to debate myself here, but Congress has been around for a long time, and it's been around since Massachusetts versus EPA, and it's been around since UARG versus EPA, and it's been around since West Virginia versus EPA, and it hasn't really done anything.
There haven't been any major amendments to the Clean Air Act since, 1994?
1990.
1990.
And the amendment to the Clean Air Act, by the way, was to add Title V, which was intended to simplify all of the complicated permitting burdens that are already under the Clean Air Act. So yeah, it was 1990, and so Congress hasn't touched it. So I don't know where you all think that kind of leaves us.
Yeah.
But
Can I just add one thing to that? I'm totally agreeing. I'm a recovering Clean Air Act lawyer myself. The principles in the major questions doctrine basically say unless the statute clearly authorizes an agency, an executive branch agency, to do something that is very significant, then they don't have that through their normal interpretation process when it really comes to that. And you look to the statute and the language of the statute, and where is that authorization? Well, in this case, though, that's the part that they had to go really far down that path to get to the rescission of the endangerment finding. But then they turn right around and say, without any statutory support, no plain language support, and in fact, direct statutory language exactly in the opposite, which is Section 116 of the Clean Air Act, there's nonetheless saying, but we can preempt everything by not regulating. So the way preemption works, this concept of preemption, is if the federal government, through statutory law, occupies the field of regulation, meaning there's a lot of regulation going on, they're really focusing on it, which is, and as an example, vehicle standards, right? Car standards, all the emission standards for all the cars, and California has that very specific pre-existing law that was recognized when the Clean Air Act at the federal level was given. So that's an example of a preemption dynamic, okay, where California has a special standing. We talked about that earlier. But absent that, if you're not regulating the field, it's like you're saying, well, there's a nice field there. No, we're not doing anything on it, but we don't want anybody else to go on there either. That's not how preemption actually works. That's not the principles of what preemption means. So that's another point, a little bit to your point, all the arguments that have been made in favor of giving them the license to remove something that the prior EPA did cut against their arguments legally that they then had the ability to, without any other statutory support, claim preemption. So there's a schizophrenia in the legal arguments that they're making.
Absolutely, they don't fit. And I have to say this because I'm so uptight. It's Justice Gorsuch's concurrence in UARG v. EPA. I'm not sure if I said that right, but anyway.
Yeah, just to affirm what you were saying about the Supreme Court, this court has shown a willingness to overturn precedent that is remarkable. The most obvious case being the right to abortion. But it's true, those were mostly constitutional cases, not statutory cases, and they're more reluctant to do so here. That said, Roberts' dissent in Massachusetts v. EPA is quite concerning. And I think he's been looking for an opportunity. We'll see if they're willing to go that far. Interestingly, on the major questions, I mean, that is a doctrine that has been revived by this court and was used to strike down the Obama Clean Power Program in West Virginia, the EPA. So if that was going too far on the part of EPA, beyond what the Clean Air Act authorized, then, and struck it down, it'd be kind of funny to just use that same doctrine to now go in the opposite direction.
It would be odd, yeah.
When there's an express provision, section 116, look it up, in the Clean Air Act, that speaks to this point, right? And gives states the express authority to regulate, as long as it's no less stringent. That's the key, right? All right, so let's pivot now, if we can, to a broader set of issues, because I think it does color California issues, what corporates are doing, and how climate disclosure, some of the California climate disclosure bills, the SEC's efforts, and then what's happened in response to this administration on climate disclosure. Christine, would you just lay out a little bit of the background there, from a climate risk disclosure perspective, and maybe sort of connect some dots there?
Yeah, happy to. I will say that, what's going on in the climate disclosure world just feels entirely consistent with this whole conversation. There's a lot of litigation, there's a lot of uncertainty. The relevance of climate disclosures to everyone in this room is it's really more in the voluntary carbon markets, because the climate disclosure rules that are still on the books with the SEC and the laws that are still on the books in California require companies to disclose their greenhouse gas emissions, but also their climate-related financial risks. And in talking about transition risks, many companies are working their way into saying, well, yes, we acknowledge that we have these transition risks, and therefore we have these goals to reduce our carbon emissions, and one of the ways that we're going to meet those goals is through offsets. So that's kind of the linkage to the carbon markets. And as I say, it's quite a similar story to the one that you've been telling here. Really quickly, the SEC has a rule on its books, and it has done so since 2024, that requires U.S. public companies, as well as foreign companies that are registered in the United States, to make certain disclosures related to their climate-related financial risks, their greenhouse gas emissions, and offsets if they use them to mitigate their transition risks, including the source of the offsets, the amount paid, and other details. As soon as that rule was adopted, there was litigation that was filed in multiple different federal courts. That litigation was consolidated in the Eighth Circuit Court of Appeals. The SEC quickly stayed implementation of the rule. We now have a new administration that's come in and said, we really don't like this rule at all. We don't intend to defend the litigation. We just want to let this thing go away. So court, just go ahead and rule in favor of the plaintiffs. And it's a little bit of the not so funny weirdness of what happens in this administration and with the courts and these agencies. But the Eighth Circuit said, well, not so fast, SEC. You can't just abandon a rule. There is a procedure that you have to go through in order to adopt a rule, and that's the Administrative Procedures Act, and you have to go out with a proposed rule and get public comment and do an economic analysis, and then consider the comments and consider the changes that you want to make in the final rule and do an economic analysis of that, and then you come out with a final rule. And if you want to undo that, you have to go through the same process. And so the Eighth Circuit said, SEC, tell us if you do not, if we end up overturning, if we end up agreeing with the plaintiffs, let me get this right. If we end up denying the plaintiff's request and enforcing the rule or saying that the SEC has to enforce the rule, will you enforce it? And the SEC declined to respond to the Eighth Circuit. It basically just sort of said, well, it's too early to say. We don't want to prejudge that, even though they had told the world that they hate this rule. So then the court actually gave them a little bit of a break and just said, well, we'll hold this in abeyance. So, you talk about sowing uncertainty. The SEC rule is basically just sort of sitting out there. I think some companies saw the SEC rule as handwriting on the wall and are using it as a framework to think about their climate-related financial risks and at least to think about their governance and their risk management, and recognizing that, in fact, whether the courts agree and whether the SEC agrees or not, they do face financial risks that they ought to be addressing.
Can I just come in on that
please.
point? Because I wanted to ask you that exact question. So it's interesting, because when this whole thing was coming up, as you can elaborate, there was a thread of securities lawyers who basically said, well, we really don't need to make any changes because it already is a material risk, and that's the basic essence of what's required to be disclosed under the existing, without any additional changes. So what you're doing with this new rule is just clarifying the existing requirements anyway, should that climate risk be material, right? It does actually help, because there's, if it's not like well understood and accepted to be material, then people can make individualized judgments, and a lot of companies might, say, well, is it material? Nah, not for us, not this year. We'll see what happens next year, So that's the benefit, but isn't it really, as a matter of law, the case that fundamentally, like, as you say, if it's a material risk to your business, you already have the obligation to disclose it, right?
So, sort of. I mean, not everything that is material is required to be disclosed. The disclosure requirements under the securities laws are encapsulated in this regulation called Regulation SK, which the SEC is now doing a sort of relook at. However, the SEC came out in 2010 with guidance that tied climate risks to Regulation SK and basically said, look, here's how you ought to be thinking about climate risks in the context of crafting your risk factor disclosure, your MD&A, which is management's discussion and analysis of financial condition and results of operations, in your financial statements, if climate risk is material. And so there are different theories about how the SEC ought to regulate disclosures. Some people think that the regulation ought to be quite broad and leave it essentially to companies to figure out what's material and what ought to be disclosed. And that's sort of a principles-based approach, versus other people who think that really the rules should be quite prescriptive and tell companies what to disclose, as, for example, with executive compensation, which is quite prescriptive. The reason that we got to the point of feeling that we had to adopt a climate rule is that this 2010 guidance came out and companies weren't disclosing climate risk. And then in 2016, there was a concept release on changing Regulation SK, and the vast majority of comments addressed climate and said that we really need to have rules that require companies to talk about climate change. And then the Investor Advisory Committee of the SEC said the same thing. So you're quite right that arguably under a principles-based regime that just tells companies to disclose information that's material under the existing structure, that companies ought to be disclosing material climate risks. The problem is that they're not.
Yeah.
And
Could I just make three small points? First, with regard to the principles-based approach, materiality is not well defined. There's a ton of case law as to what is material, and so that gives a lot of leeway right there to companies to decide what is or is not material. The second point I just wanted to make with regard to the litigation before the Eighth Circuit, yes, most of the plaintiffs were challenging the rule, but there were other plaintiffs that were saying it didn't go far enough. So so if the court were to say follow the SEC's rule and rule in favor of the plaintiffs, well, which plaintiffs? That's a point. And then the third little point I want to make, which I think will pivot for you, which is that the SEC rule applies to public companies only. Mm-hmm. California's laws, the 200s, apply to public and private companies above a certain revenue threshold. How you determine that revenue threshold is still being worked out in the rulemaking process. It's $500 million for climate-related financial risk, and it's $1 billion annually for greenhouse gas emissions reporting. That SB 253, which is the GHG emissions reporting, that is currently being stayed by the Ninth Circuit on one of the several legal challenges to those laws. We'll see when we get a decision on that. Meanwhile, the rulemaking is ongoing, but maybe you should speak to that more.
Yeah, I mean, that was a good summary. So currently we have on the books in California these two laws, SB 261, which is a climate risk disclosure law that tracks to the SEC and really the disclosure regimes around the world. SB 253, which has the higher revenue threshold, the $1 billion threshold, requires companies to disclose their scope 1, 2, and 3 greenhouse gas emissions. As Nico said, these are in litigation. Sort of tying back to the preemption theme, it's quite interesting, you know, if you want to sort of track the litigation drama. The litigation was brought challenging these two laws, initially in the Central District of California, and the plaintiffs requested that the court stay implementation of the rules or the laws until the litigation can kind of work its way through. It hasn't even gone into discovery yet. It's going to be a long and protracted process. The claims that were brought were related to First Amendment. So basically, and you all think about First Amendment as being, you know, that you should be free to say what you want to say without interference by the government. There's this other doctrine within the First Amendment, which is a compelled speech doctrine, which basically says that the government can't compel you to speak on matters that might be controversial or matters of opinion as opposed to issues of fact. And so that's the First Amendment compelled speech argument. So there was that, and then there was an interstate commerce claim, which was dismissed by the lower court. And then there was a preemption claim, which was also dismissed by the lower court. And the preemption claim looked at, it basically said that California is preempted by the EPA, and so it doesn't have the authority to regulate disclosure related to climate. The lower court dismissed the preemption and the interstate commerce claims and didn't dismiss the First Amendment claim. So that kind of continues. In the meantime, the plaintiffs requested that the court stay implementation of the laws until the litigation can kind of work its way through. The lower court said no. It's now been appealed to the Ninth Circuit. The Ninth Circuit has stayed the implementation it has to still decide on that stay, but in the meantime, it's temporarily paused implementation of 261, which is the climate risk disclosure law.
No. That one's allowed to go forward.
No,
261 that was stayed. 253 is going forward.
Well, so the Ninth Circuit came in and said, we're going to have a hearing, right? They held a hearing in January. Before that hearing, 261, which is the climate risk disclosure law, was supposed to go into effect on January 1. So the Ninth Circuit came in and said, hold on, you don't have to make your disclosures on January 1. Let's just see what we end up deciding in our hearing or after our hearing in January. So they held this hearing in January, and we're still waiting for the Ninth Circuit.
There's some detail here that I think is relevant to the nature of litigation in the current environment. They sought that stay from the Ninth Circuit in the summer. In the fall, the Ninth Circuit said, nah, we'll just keep it on. They then filed an emergency appeal to the U.S. Supreme Court. And a week later, the Ninth Circuit said, okay, we'll give you this stay for 261. And I mean, I think the Ninth Circuit didn't want the Supreme Court taking the case away from them. Those are very unusual maneuvers that are the kind of things, let's not even talk about the shadow docket at the Supreme Court, that are going on right now with this court. And so the courts are getting more political. Let's just leave it at that.
Yeah. I mean, it's high drama, really. Like, if you like to follow this stuff. So the last piece on this is that in the meantime, another lawsuit was filed by different plaintiffs in a different court in California, making the same claims. So First Amendment maybe it didn't include the dormant commerce clause because they kind of saw that that was not going to be a winner, but they also included the preemption clause. But instead of pointing to the EPA as the agency that preempts California, they pointed to the SEC. So just kind of like, diversifying and trying to find different angles. So there's a lot of litigation. It's going to take a long time to work its way through. It's sowing uncertainty and doubt, and I think leaving some companies are just proceeding apace. They're continuing to report, or if they're not reporting, they've kind of done their initial SV 261 climate risk analysis, and they're sitting with these analyses that show that they really are subject to climate risks that they need to deal with, and in many cases, I hope, are continuing to try to mitigate those risks.
More than 100 companies did make their disclosures on January 1.
Yeah. So I think we have 15 minutes left in this session. That's right. I'd love to have anybody start thinking about questions they might want to ask. Okay, based on all of this. But I wonder if it's worthwhile maybe doing a little bit of a recap, and then I want to spend a few minutes just on, all right, what are we seeing as practitioners in the space, advising clients? As you said, it's high drama and all that, and confusion. But Nika, you just alluded to the fact that 100, that's far less than the total quantum of who would otherwise be filing. But you start to get this sort of breakout of various groups of businesses, companies, clients, and the like that take different approaches in an era of, let's call it more kind of volatility in the context of policy in the United States, because you never know what's coming next at 3 a.m. From certain parts of our government. So let me, Andrew, start with you. Like in your and again, like you're in the renewable space, so I'm sure that, like, for example, the investment, the IRA, has impacts.
Well, there is a lot of policy uncertainty that was generated in part by the One Big Beautiful Bill Act. It's hard to, OBBB, I guess is what people call it. I don't know. But you look at the law and you look at the press around it and you're like, oh my gosh, renewables are going to scale back dramatically in the United States because of the hostility of this administration to renewable energy. And now this doesn't relate directly to markets or SEC disclosures, but it is, I think, what I'm about to share is indicative of an actual trend. There's the loud noise that's coming, and then there's the reality on the ground in terms of what's actually been installed and what will be installed as part of the energy transition, at least in the United States. And I want to benchmark a couple of things really quick. In the lower 48, peak electric demand is about 760 gigawatts. Peak generating capacity is about 1,300 gigawatts. So just kind of keep those two numbers in your mind while I rattle a few of these stats off, because I haven't committed them to memory, obviously, so I have to read them. Between 2020 and 2025, there was roughly about 150 gigawatts of solar installed for a total cumulative capacity of about 279 gigawatts of solar. Okay, just solar, nothing else, just solar. And solar is a capacity resource that helps reduce emissions and meet electric demand during peak times and so forth. You all know that. And it was a growing trend with the IRA, the Inflation Reduction Act in 2022. But I think what's kind of, and projects dipped a little bit in 25. Okay, I think partly around the tariff uncertainty, partly around the tax credit uncertainty and so forth until IRS guidance came out. But I think what is really interesting is what is projected in forecast for 2026 through 2030. If we're already at 279 gigawatts, we're like, close to half of peak electric demand in the US from solar alone. That is going to grow really significantly by another 250 gigawatts, they're estimating, or at least the Solar Energy Industry Association is estimating, by 2030. That is a tremendous amount of renewable deployment. And on the ground, I see that happening. I negotiate solar panel purchase agreements for large buyers of solar panels. And when, I don't want to get too heavily into the tax credit discussion, but there was a cliff, essentially, that kicked in September of 2025 that said, you know, if you want to get the full benefit of the tax credits, you basically need to safe harbor your project by September of 2025, and that gives you 4 years to build. And boy, was there a buying spree on solar panels that summer. And then after September, you have to show actual physical work. And you can do that too by buying a main power transformer for your project that's going to go in service. So there is a tremendous pipeline of solar projects alone that are going to be installed in the United States that will help partly meet rising electric demand to data center demand and things like that, but will also offset and displace higher cost sources of energy, ultimately, hopefully, either offsetting or reducing emissions. So the reality on the ground from like a project development perspective is that we are proceeding apace. The energy transition is happening because it's cheap, it's clean, people want it, corporate buyers want it, utilities want it. It's just happening. And I could rattle off similar statistics for battery energy storage systems too. I just finished negotiating $1.5 billion worth of energy storage for one buyer in the US. And what does energy storage do? It enables renewables integration. It enables more solar, more wind, ultimately. So that's, it's maybe a sunny view, no pun intended. But I don't, picking up on Rick's point, there's, like I said, there's the noise and perhaps maybe the high drama, and then there's actually what's happening in the project development market.
Christina, can you speak a little bit to that and kind of the work that you do with the Conservation Fund? Sorry. Can you speak to that, the work you do with the Conservation Fund and what you're kind of seeing on the ground as well?
Yeah, happy to. So I've been with the Conservation Fund for only 2 months, so it's still pretty early going. I feel incredibly fortunate to be in this space, largely because I've spent the last 10 years or more counseling clients on climate-related financial risk disclosures, working at the SEC on the climate rule, counseling companies on their SB 261 disclosures, et cetera. And it's a tough time to sort of convince companies to make voluntary disclosures at this point. At the Conservation Fund, we do a number of things. Our basic business model is we buy high conservation value lands that are at risk of going to development. We put conservation easements on them, and then we sell them. And for forest lands, which are our largest type of land holding, we'll put forest management programs in place. We'll develop some timber and some carbon, and then ultimately sell the projects to state, federal, local agencies, to Native American tribes, or even to corporates. And the drivers of this kind of investment on both sides, participating with us, are many. And so we're benefiting from the fact that, for example, many data center developers really want to try to find ways to mitigate the impacts of their project development. We have partners who are really concerned about water, others who are concerned about conserving migratory pathways for wildlife, or conserving hunting and fishing and recreational lands. And so we're actively in the carbon markets, but we have the tailwinds or the additional support of other reasons that kind of drive our transactions. But on the pure carbon demand side, we are continuing to see demand both in the compliance markets and the voluntary markets, because companies, if they have compliance obligations, they have those obligations. And in the voluntary markets, there are still a lot of companies that really just want to offset their emissions, either because of commitments that they've made or because of their relationship with the communities in which they're operating, or for one of the many other reasons that I articulated. So I feel really fortunate to have kind of found a way through this that's where, I feel like I can do some good and continue working without just completely pushing a boulder up a hill.
Go ahead,
And
Andrew.
I just wanted to piggyback on that as well. In addition to the project development stuff that I do, I also help large institutional buyers purchase CDR, carbon dioxide removals, not so much offsets, but like actual removals. And the level of interest in buying those removal credits, the level of interest in buying sustainable aviation fuel environmental attributes is only growing. And the commitments are real from these companies. It's sincere, they want to do it, they're willing to pay for it, and it's all voluntary. These are not for compliance. This is just because they think it's the right thing to do, and frankly, they like to brag about it a little bit, and I don't blame them. It's really neat. And they actually, in my experience, they're actually really diligencing these projects. They really want to understand how the carbon is sequestered or captured in a biochar deal or something. They really want to do the diligence. They are invested in the quality of the credits and supporting a lot of credit generation through direct investment by offtake, or sometimes even just investing in the projects or expressing an interest in investing in the projects. So just to piggyback on that kind of note of hopefulness, that corporate buyers are interested in this, not just for compliance. They're interested in doing it.
I would just like to make two brief points in terms of getting away from the Sisyphean tale. And that is, I think there's a very decent chance that the rulemaking around 261, when it picks up, will include a provision that will basically say, if you're mitigating, as part of your strategy to address the transition, you're going to mitigate using removals or reductions, look to these CCP stamped offsets or whatever, and we will consider that a valid form. It's not regulation, it's not endorsement, but it provides a good defense against greenwashing lawsuits. And this is not an irrelevant point, although there's been a lot of folks running away from this market because of concerns of greenwashing lawsuits. There was a decision recently in the district court in San Jose. Someone brought a lawsuit against Apple saying that their use of offsets was illegitimate, and the court threw it out and it ruled in favor. So don't be afraid, essentially, is the indication. There's increasing support legally for use of these carbon credits. The other point I wanted to make is that I mentioned earlier the Trump 1 administration suit against California's cap and trade program's linkage with Quebec. I represented AIDA, is an intervener on the side of the state in that lawsuit, and I think that it was really important. That judge is handled the only other case in which a state program was held to overstep its police powers and was struck down by that judge, a case concerning California had a law allowing folks to bring claims for stolen artwork during the Holocaust, and after it was adopted, the U.S. government set up its own program, and they said, okay, you can't do that because it's preempted by foreign affairs doctrine. So he was predisposed in that direction, and it was the presence of the market participants, and it's not just a policy dispute between state and federal, that I think was really important to the court's decision, to recognize the economic importance to the private sphere, the civil society, that made a difference. So in terms of the shock and awe and all the noise that is causing so many universities and law firms to take a knee, it's important that this market, I believe, stand up in the event of such a lawsuit.
Yeah, good, well said, well said. All right, I'd like to move to questions. I know you have a hand in the back there, and please, I don't think we have roving mics, so if you don't mind standing up or just shouting out and your name, who you're with, and then welcome your question.
All right, I'll try to do that. My name is Kathy. I'm with Marcus Media. I know we spent a lot today talking about what options the federal government has in court. Like Bill said, wheels of justice turn very slowly, and we are in year 2. What kind of extrajudicial options do you see as being on the table for the federal government against these state-led policies and programs, whether that's RPS, cap and trade, disclosures, taking?
Extrajudicial, meaning like if they don't want to wait for that process, what's the strategy?
Well, we've seen some examples. Due to the scandal of fraud in Minnesota, the administration is pulling funding from a lot of other states' healthcare provisions. Those are already being challenged in court. I don't think they're likely to go anywhere. But I mean, what the government has is the ability to withdraw funding, and they've certainly shown that with universities and others. And there's certainly a lot of federal money that flows to states. So it's they're unrelated because it wouldn't address the money flowing for climate programs. But you could see something like that. I don't think they would be very successful.
Yeah. Any other thoughts?
Pulling project approvals on federal lands for renewable projects is, or not pulling those approvals, but also requiring approval by the Secretary of DOI.
They adopted that regulation, an order. Every single, I mean, not even routine permits, things that aren't actually issued new permits, but just rubber stamping a deliverable on a permit, has to be approved by the Secretary of the Interior. But that is being slowly undermined within the DOI.
Yeah, and also DOI just approved the sale of some federal land to a solar developer in Arizona recently for a substantially large solar project. So, again, on the ground is where the reality sits.
Right.
There's also a provision that's making its way into contracts with the federal government, whether for funding or otherwise, that says by entering into this agreement, the counterparty certifies that it's in compliance with all the executive orders, which is really hard because we can all correctly believe that the executive orders are illegal, they don't hold any force of law, et cetera. But, I can't really tell my clients to sign, and I'm not going to sign a document that certifies that we're in compliance with all these executive orders, including the DE&I ones, and, it's tricky.
Yeah, power of the purse. Yeah, that's good. Sir, please stand up, identify yourself, who you're with.
Seems kind of harsh, Rick.
Well, so my question is back to the executive order and compliance market. So non-lawyer, but I, as a layperson, I think executive orders can be challenged. Some have been found to be illegal, unconstitutional. In this instance, we're waiting for the lawsuit to drop, and then possibly there'll be the effort against it. Why not preemptively go after the executive order? And the kind of the injury, I suppose, or you have to demonstrate why you're a party to the case, could either be that California is not getting the revenues that expected, or it could be market participants feeling like there's a lot of sort of turbulence and shock because of that. So is there a legal strategy around, well, the executive order itself, regardless of what the lawsuit that comes out of it, is illegal or possibly unconstitutional?
I think actually no, for this reason, which is that some executive orders have had or purported to have direct impact, such as birthright citizenship now before the Supreme Court. This one didn't. The actual only thing that it ordered to be done was for the Attorney General to prepare a memo. That was, in terms of what it actually specified, it basically described this terrible risk of state overreach, but in terms of what to do about it, Attorney General draw up a plan. So there's not a lot of there. In terms of the actual impact on the market, that's going to be a little bit attenuated. So it'd be harder to make a claim that there was a causation between the one and the other.
Also, remember, there have been a lot of executive orders. So as to certain executive orders, like the ones attacking the universities, a lot of universities just sort of, complied and gave in to the government. But Harvard and some other universities did file lawsuits to challenge them. But it's a scary thing to do. I mean, taking on this government is, it's not for the faint of heart.
Tell me about it.
Yep. Okay, I think we have time for one more question. Anyone? But there was one more over here. Somebody have one? Yeah. Yes, please.
Hi, Teresa Keith with 3 Degrees. It was a follow-up question from Denise, actually, in terms of extrajudicial measures. We've seen recently this strategy of, okay, well, the wind project is going to go ahead, so we'll just pay them off, pay them to stop. In terms of, federal relations with corporations going forward, do you see that becoming a trend, a
Sorry, pay who up?
She's referring to the Total Energies project, but paid $1 billion to withdraw it and
Yeah.
instead do oil and gas. Yes, I do. I mean, you can just look at the crypto scene. I mean, there's all kinds of backroom deals. I mean, this is a deal precedent, right? So sure, there's going to be more of that. That's become the new normal.
Okay. All right, well, with that, I'd just like to thank the panelists. Very good discussion. Folks who have more questions or they want to chat on the margins, you know, I know I'll be here for another day, and if there's folks, you know, we welcome further conversations. This is a lot of complicated, nuanced, you know, discussions. I guess my takeaway is as follows. You know, a lot is going on, but that's kind of just, in a way, normal BAU at this point, right? And I think California has positioned itself that way. And so my, I guess, only admonition, if that's the right word to say, is don't necessarily overreact one way or the other, and even keel, you know, focus on the real stuff that matters, and don't be overly excited by the noise. I think that's really helpful, because some stuff there'll be some wins. There have been some wins from this administration. Things have been eroded for sure. It's not the same. And the elections matter. You know, the policy of the United States is not climate friendly. I mean, that's a bottom line, and so that has consequences. But there are, you know, very strong legal foundational protections for things like the state of California and other programs that you know, cannot just be summarily you know, eliminated by an executive order, you know, in particular. But the battle rages on. So thank you very much.
Thank you.